Good morning and welcome to the Family, Children, and Custody Subcommittee meeting of the California Paraprofessional Program Working Group. I'd like to start by calling roll. Bashan? Didn't see Sharon. Hamilton?
Present.
McRae?
Here.
Olvera?
Here.
Sarouche?
Here.
Judge Wiley?
Sorry, here. Thank you.
Great, thank you. So for Reba, do you want me to check to see about if there are any members of the public that want to make
Yes, let me
comment?
just get started by saying what we're doing today and then invite public comment if you don't mind.
That's fine, thank you.
Wonderful. Good morning, everybody. Welcome to this meeting of the Family Law Group. Today, we are discussing child welfare and guardianships and conservatorships. We have guest speakers, which I will introduce soon. We will also cover the issue of in-court representation as to these subtopics because the full group already decided on that issue, and I think it's important for us to discuss that here today. And then we will also need to set another meeting to discuss in-court representation for family law and also in general the issue of fee caps. And I believe Linda will send out a doodle poll at some point after this meeting, so we can do that. And at this time, if there are any requests for public comment, let's please raise your hands now so Linda can let you in.
If anyone wants to make a comment, raise your hand in Zoom. I see 4 attendees. I don't see any raised hands. So.
Okay. And we can always come back to that if that's okay. Yeah. All right. So I am so delighted that we have 2 subject matter experts on the issues we're discussing today. First on our agenda is child welfare. And so I'm going to introduce a good friend, Mary Feldman. We've known each other professionally, gosh, since I was lucky enough to have her on my staff back in 2002, I think. But then she was destined for bigger and better things, and she followed her passion. So Mary became an attorney in 2000. In 2007, she joined the Dependency Council at the Dependency Advocacy Center. Is an agency that represents parents. They're court-appointed attorneys for parents in juvenile dependency court. And she was a staff attorney there until 2013. At that point, or until 2016. In 2013, she was certified as a child welfare law specialist. So she has lots of knowledge to share with us. She's currently in her own firm. She still represents parents in juvenile dependency court as private counsel. She's also appointed to high conflict cases as the minor child's attorney in family court. And she's part of the partnership of Feldman and Sethi Law and Mediation. And that's brand new as of March. Congratulations, Mary. And Rashida, who used to also work for me. I'm so lucky. All right, so I've invited Mary to go over the task list for the child welfare portion of our discussion. And she's done that by creating a great PowerPoint. When you joined the meeting today, you might have overheard the discussion of Mary is going to talk about tasks from forms to also in-court representation. Not that we've voted on that yet, but I think it's useful to hear all the different stages for each task or motion or issue. So without further ado, I'm going to turn it over to Mary. Mary, do you want to share your screen for your PowerPoint?
I'd love to, if I can.
I don't know. Linda, can you make her a call so she can?
It looks like it let me.
There you go.
You see it? Okay, I'm going to go through this.
Thank you and welcome.
Thank you. When Fariba contacted me, she said, think of all the ways in which somebody might use, a self-represented person might need some assistance with forms or filing or understanding what's going on. prior to filing a juvenile dependency case. But I said also, while a case is open and after case is closed, there's a lot of times when people might want to file something. I'm going to go through this kind of quickly because I understand that this might not be appropriate, but it's still really interesting. I won't take much of your time. So the most important thing, whoops, I'm having a little trouble with there. In juvenile dependency court, everyone gets an attorney. Each parent gets their own attorney. The child or children get an attorney. Sometimes the children have separate attorneys if there are conflicts of interest. Of course, the department, which we call the agency, CPS, Family and Children's Services, they have a government attorney. In our county, it's county council. People who don't get attorneys and don't have a right to bring in an attorney, even to participate, are foster parents primarily. And they have a lot of questions. Grandparents, siblings, other relatives. Sometimes it's somebody who's not actually a relative, say mom's boyfriend. They can be permitted to attend the hearings, but they can't address the court without permission. They have a limited way to get information to the court. And in private practice now, I'm one of the few dependency attorneys in our county who's in private practice. Almost everybody works for one of the agencies. People come to me all the time and say, my grandchildren are in foster care, or we're the foster parents and we don't know what's going on in the case, or we want to get information about the case, or we want to share information with the court. And so there are some limited things that they could do. I'm trying to imagine how could a paraprofessional help people in that situation? So the number one thing, and probably you've heard of it, is what they call the 388 petition, which people just as easily call the JV 180, means exactly the same thing. JV 180 is the form. It's used for two things in dependency court. One is to change any order of the juvenile court. It can even be after the case is closed. I'll give you some examples. And the other, completely separate, is to assert a sibling relationship. So here are some examples, and that can only be filed while the case is open. So these are typical examples that people would come to me. There's grandpa, his kids in foster care, his grandson's in foster care. He wants to visit. There's no provision for it. The social worker doesn't answer his calls. Grandpa might want to file a 388 requesting visitation. Here's another example for once a case is closed. Mom failed to reunify with her kids, so they were set in a permanent plan of legal guardianship. Because at the end of a juvenile dependency case, and they always end, the kid is either returned to the parents, parent or parents, placed in a legal guardianship, parental rights terminated and freed for adoption, or in the sad cases, and unfortunately so many, placed in long-term foster care, where the case remains open indefinitely, reviewed every 6 months. And those are the sad teenagers that go from foster home, and then, I'm sorry to say, end up going to jail or become homeless because they didn't receive the support they needed. But often when a case is closed with a legal guardianship in place, later on, mom gets clean and sober, mom gets a stable job, mom's doing all great, she wants her kids back. She can file a 388, even though the case is closed, to reopen dependency, to say, I want to get more services, there's a niche market for that, to say, I want my kid back. And the standard, as you would expect, is significant change in circumstances and best interest of the child. So she could file a 388, and people do this all the time. We get handwritten 388s, and the court takes care of service, but people just have to get that paperwork to the clerk's office. I like to say, when you see forms, and you probably know this, forms with a big black box around the form number at the top, those are designed for ordinary mortals to be able to fill out, whereas the other judicial council forms, generally look for an attorney. So this is one of those. It's designed in simple terms. It asks the questions, what has changed? So I'll show you those in a second. Another example is we got a guy and his sibling is a dependent child in a foster home, and he can't get through the social worker, and he wants to have contact. He wants court-ordered visits with the sibling, or wants to say, hey, I can give a home, basically to assert I am a sibling. This person does not need to show a significant change of circumstances or best interest. All this person needs to do is show that they are a sibling. And I recently filed one of these for a 10-year-old sibling who's of a baby who'd come into protective custody, and it was placed in foster home, and the adoptive parents of the child's biological sister, who was 10, wanted her to get to know the baby sibling. And so we filed one of these, and it was in another county nearby, not Santa Clara County, where they wouldn't have made this mistake. And the judge denied it and said, no change of circumstances or best interest shown. And I did a quickie appeal, which it totally got reversed, like you don't have to show that. So that's something that ordinary people might want to do. And then here's the gotcha question. This happens all the time. Somebody fails to reunify with their kid, adopted by somebody, like by his cousin, Now parents doing great, got all this clean time, discharge, parole, everything's stable, wants his daughter back. And yeah, even the kid wants to come live with him. Not the subject of a 388 because the case is closed. Adoption is final. So there's nothing this dad can file in dependency court to set that aside. However, he and the kid could go over to probate court and make him the kid's legal guardian. I'm doing one of those right now. Okay, so those are things you could do. And here's a quick example. I'm going to now share. I'm going to share the stack of forms. Can you see the form? Okay, so there's the JD 180. If you haven't seen it before, it's designed for ordinary people. It says, is it too small to see? You can see it okay? Not if you can see it. Okay, so you just say, who am I? I'm the child, the parent, the guardian. I can be somebody else. Pretty much anybody who has an interest in the child can file a 388. They have to put down as much information as they have. But look at number 2, asking the court to change an order. Generally, if you're asking the court to terminate its jurisdiction or terminate reunification, attorneys are going to file that. That's when the department files it or the minors council files it. The ones that ordinary mortals file, and that's just a term I use, is asking the court to change an order or asking the court to recognize a sibling relationship. And it can be half sibling, it can be full sibling, it can be sibling by adoption, it can be step sibling. And then you put down information about the child. You have to list, and they've designed it for people to use easily. On this date, the judge made this order. What happened since then? That's the change of circumstances. What do you want now? Why would it be better? And then write us a little story and attach it. So these are things that people totally do by themselves. There's this tricky part here, which I think that members of the public or non-represented people would not be required to comply with this part. Attorneys, when they file a 388, have to list all the people that they know here, kid's attorney, parents, who everybody, CASA, there's a tribe involved, county council. They have to send it out to everybody first and ask for responses, just a yes or no. I agree with it, I don't. Put the answers in here. So before they file it, they have to have indicated what everybody's position is. I believe that they waive that, at least in this county, for self-represented people because they wouldn't know how to do that. And then the court's going to do that. Okay. The other form that people would need help with is if you want to file a 388, but you don't want your information to be there and you don't have an attorney, you attach a confidential information form. It just gets filed with it. Okay. And then the next thing I'm going to talk about, and switching back to this PowerPoint. The next most common thing, we see this all the time, de facto parent. And de facto parent independency has a special meaning. It's created by case law going way back to, I mean, the big case is 1992, but just a second. My internet was unstable for a moment. Am I moving? Okay. So a de facto parent has this definition. It's really broad and it's subject to a lot of interpretation. And there's tons of case law about what qualifies as a de facto parent and what doesn't, because the original cases said someone who has acted as a parent and fulfilled the role of a parent for a substantial period of time. What is a substantial period? I talked to a friend of mine who was a serial foster mother forever. And she said, 20 years ago, or well, probably 15 years ago, she would file a de facto parent request as soon as a baby was placed with her and it would be granted. Now, at least in this county, they think that at least 6 months should go by. So sometimes foster parents immediately apply to be a de facto parent as soon as they pass 6 months. So that's something that they could get some assistance with. It's a pretty simple form. I'll show you the forms. It's a complicated area of law, though, gotta tell you. But the form is here. Very simple. You file this request and you say, this is my name, and we want to be de facto parents, and we sign it. And then we do a statement and we say, here's how long the kid has been with us. Here's what we've, the responsibilities, kind of describing the relationship with the kid. People sometimes write pages and pages and attach all these pictures showing what a great time the child has in their home. That's fine. And then it can get set for a hearing. Used to be, they were pretty much granted routinely. Now it's a bit stiffer. They're getting a lot more contentious because once you're a de facto parent, you have the right to have counsel and sit at the table and participate in the hearing, and you have the right to notice of things that are going on. You still don't have a right to receive the social work reports, but you can sit in a hearing. And so I'm wrapping up representation of some foster parents who became de facto parents when the child was small, never expected the child to reunify with mom. It looked like the longest shot in the world. And then the child reunified and they were deeply hurt and they wanted to retain their de facto parent status. And so it became a big battle, but we're going to move on. That's something which lots of people do. A grandparent does it. Doesn't have to be somebody who's got care of the child. So if my granddaughter, which, I don't even have a granddaughter because I'm waiting to have grandchildren, we're taken into foster care and I want to maintain, I say, I know this kid really well and I've cared for her a lot, even though she wasn't living with me when she was removed from her parents, but I don't want to be her de facto parent because I have a psychological bond. So I've got to file this. It's up to the court whether to appoint counsel for de facto parents. It happens sometimes, but they're not entitled to appointed counsel, but they are always welcome to retain their own counsel. And a lot of de facto parents come in and they don't have counsel because they don't need it, but they just want that status so they can sit at the table. And it can have ramifications later on if the child's going to be adopted. Okay, so next we're going to look at, I'll go back to the PowerPoint. Other ways to get information to the court. And so these are simple ways that people don't know that they can get information to the court. Caregivers, so anybody taking care of the child, foster parent, relative, whatever, can submit a caregiver information form. And yes, the social worker should tell them about this form, but sometimes they don't or they slip it. And the parents are never going to tell them about the form because the parents always think that the caregivers want to just keep their kid. And then sometimes there's a relative who's not a caregiver, but just has important information. They're not asking to be a DFP. They don't qualify for that, but they want to provide information. And then sometimes these people want to do it confidentially, and there's a separate confidential information form for those people. And here's the stack of forms again. So there we go. The caregiver information form doesn't look like something that's designed for ordinary people to fill out. It's got lots of fine print on it, and they want lots of information and the details here. What's going on with the education? I've got new information or nothing has changed. Special ed, adjustments, whatever they're doing. People that are taking care of a child who never appears in court and it's just a name on a paper to the judge often really want to provide this information. And so they could get some help doing this and drafting up their material and attaching it and getting it filed. Once again, the court takes care of service. They don't have to mail it to everybody. They just file it with the court and the court does the service. In dependency, the court has a lot of responsibilities for service. It's not all on the department. So there's the caregiver information form, and then relative information, once again, is one of those forms that you think the public could do. And it's just, I've got information I want to share. So providing the form and helping somebody fill it out and get it down to court would be helpful. And these are the things I want to do. I want to go to visits. I want to attend the medical appointment. I have information and I'm a relative. Got to tell you, these are almost never seen in our county. And I found it there, and I think that people should use it more. Okay, so then back to the PowerPoint. I'm almost done here because the room, and those are those forms. Okay, the other big challenge for people who aren't represented is getting access to the dependency case and the child welfare system records. They're both the dependency court file and all the records at CPS about the child, all their social worker notes and everything. Those are all considered the juvenile case, and the same statute applies even if there's not a dependency case open. If somebody wants to get access to a child welfare report, to a social worker referral and investigation, there's two ways to do it. Welfare and Institutions Code section 827 makes it all super secret. There's a list of about 13 different types of people, 13, 14, 15, 17 different types of people who can have access to these things, but then they still have to actually get the access. It's one thing for the statute to say you can have it, but if you're not on that list of people, you who are, the parents, the court staff, CPS, judges, the attorneys that are actively working a case involving the child, if you're not one of those people, you have to petition for access. And it's a complicated petition, but once again, it's something that, the forms look like people should be able to manage them, but they could use some professional help. And it could be much simpler because you have to file both a petition for disclosure and say why. You have to file a notice. Then you have to, 10 days later, you can file it after you've served everybody. And there's a special proof of service form. I said to everybody and their brother, I'll show you the form. You have to notice everybody that could possibly be involved in the case. And here it comes. Okay, so so there's the petition, the request for disclosure of the juvenile case file. All this white space is misleading. It's actually asking for a lot. I'm going to tell who you are and what relationship you have. And you have to say, is this a 300 case, meaning juvenile dependency, or a 600 case, meaning juvenile justice in this county, or juvenile delinquency in some counties. And then you have to say what records you want. Well, you might not even know the records that exist. So just knowing how to refer to a broad group of records without knowing what they are when they were filed. If there's because of another case, you have to say what the case is. Maybe you got something in, settling some estate and you need some record. Maybe you are a tangential player in the dependency case, but there's a lot of social worker information about you that you want to use in some other case. What if you were, a young woman petitioned in probate court to get visits with her brother her little brother who was in illegal guardianship. And then she was told that there was a child welfare report about her. And she wants to find out what the heck they said about her. Well, there's no dependency case. The kid is in a guardianship, but there was a social worker investigation. So she wants to get access to find out what they wrote about her. You have to describe in detail why you want the records, obviously. And then you have to send this notice to everybody that says, and it is everybody. On this proof of service, it says, I've served copies on this on everybody. And here who have to notice: the district attorney, the child, the attorney for record, the parents, the guardian, the probation department, if there is one, child welfare service. You have to serve also, I believe, the state social services. If there's a tribal rep, you have to serve a CASA. So you really have to show that everybody has an opportunity, and you have to attach, of course, the blank objection for them to fill out, just as you would in any motion. So it's complicated, and people could use help with that. Then the other way, I'm switching right back to, I'm going back and forth between these pretty well. Even if you are on the list, you still have to go through a process. And as far as I can tell, it's local rules prescribe the process. In our county, we have a form. So even if you're the parent, even if you're attorney for the parent, you want to go down to the court clerk's office and you want to see the dependency file, you still have to do a form. You can't just show up and show your ID and say, I'm the attorney of record, you've got, or I'm the parent. You fill out the form and it becomes part of the file, the fact that you looked at it. And if it's not a dependency case, you have to request directly from the agency. I've got a sample letter, and they also have a basic form in this county. Let's take a quick look at those. This is the local form in Santa Clara County, Declaration for Juvenile Court Record. I have to say who I am and why I have a right to look at it, and then this becomes part of the permanent file. If you go down to the clerk's office, you're a parent, you're whatever, they'll give you the form to fill out. And so you could do it right there, maybe, but if you're limited English, or, they don't have a Spanish version of the form, you might say, how do I get this? And someone could perhaps help you by providing the form. Believe it or not, this is what I use a lot of times. I do this so often that I have a blank form and I just write it out and I email it over to social services. No, if I'm going for the court file, I go down to the clerk's office, as they say. But if I'm just wanting anything else from DFCS, I fill it out. I say I've got usually a family court case. I represent the mother or the father. I put the names and dates of the birth of the children, and I attach some sort of proof showing who I am. And so this is one that I did last couple of weeks ago. Here's a little form that our local county has for people who can't put it together to write a letter. They write down who they are and what they want. And then until COVID, the CPS would call and say, your records are ready, come pick them up. And then you come and show your ID and sign for them. But now they will send them to you encrypted. So I think that's the end of that. Oh, the last thing I thought about that people come to me who are not represented, there's not necessarily a dependency case, but it's related to child welfare, is, which screen am I sharing? Am I sharing the PowerPoint? Oh yeah, the CACI index. So you can get the Child Abuser Central Index. You can get on that for lots of different reasons. And they send a letter and says, you're on the CACI index, and here's this stack of fine print forms. But the most important form that somebody would need to fill out and file in a timely manner, and they're not going to be getting any legal help to do it, is this request for a grievance hearing. You got to get it in within 30 days and say either you made a mistake, I shouldn't be on the CACI, I didn't do it, or I did those things, but they don't constitute something that should be on the CACI, and then they can have a grievance hearing. Now, I think people should get an attorney if they're going to a grievance hearing, but they don't have to, but they do need to get this form in. And sometimes in family court cases, a parent says, I just got a notice that I'm on the CACI because child welfare investigated, they decided something, the custodial parent was being protective, they don't need to take the kid away, they don't need to open a dependency case, but they did report one of the parents to the CACI. So people might need help with that. And I will now stop sharing, and I think, yeah.
Oh my gosh, we should get CLE points for this, okay? Incredible. Thank you, Mary. I thought that was really great. I have a few questions. I'm gonna open it up to the committee members for questions. So the way I see it, really, the only forms that would result in a court hearing for the applicant are the JB 180 and the de facto parent request, right?
Those are the only ones that would cause a hearing, but most of those others would be, you file them right before a hearing to provide information to the court at the time, not just in between hearings, you file it in conjunction with a hearing.
Right, but it doesn't require you to actually go to court and be part of the hearing. As a matter of fact, you're not authorized to be there, right?
Correct.
Right, and then that last one, that results in sort of a administrative hearing, right? Okay, all right. So I'm gonna open it up. Thank you, Mary, it was wonderful. I'm gonna open it up to questions. Anyone have any questions? Sharon.
Thank you. Thank you so much. This was a great presentation, Mary. Where do self-represented foster parents and other folks go right now? Are they going to self-help? Are they trying to seek assistance from legal aid organizations?
They, in this county at least, they turn to the foster parent and kinship. There's like a club or a organization that get a little office over at DFCS, so they share information among each other, support groups, other foster parents, they talk about how to do it. And sometimes the Minors Council will, get friendly with the foster parents and tell them, hey, you might want to file this form. I'm not going to do it for you, but you might want to look into it. And sometimes, it's like word of mouth, as far as I know.
And as
And
far
we
as
help with JB 180, and I'm seriously considering adding more from Mary's list to our list. I was not aware of all this. That's why I'm so grateful to you, Mary. Go ahead, Sharon.
So as far as you know, Mary, they usually are unrepresented unless they can afford an attorney. And how often does that happen?
Not very often. And we're talking about the relatives and foster parents and things. People contact me all the time and they want help and they don't have any money at all. And, I'm a softie and I do, like I help them with the forms and I say, but I can't actually go into court with you because it can turn into a real slippery slope. But word gets around. And so I usually give people a half an hour, an hour of just tell them how to do it. And sometimes if they say, well, I got the forms filled out and then I'll file it for them.
Well, good for you for doing pro bono work,
but
that's wonderful.
But they, they're sort of on their own.
They're on their own. And are you of the opinion that these are tasks that would be appropriate for paraprofessionals to undertake?
Those are the ones that I looked through that I thought, yes, a skilled paraprofessional could help with those because they don't involve a lot of legal advice. They're fact-based, put this down. Now, the de facto parent request, there's certain, if somebody's going to oppose it, there are about 5 factors that the court's going to look at. So if an attorney prepares it, they're going to make sure they hit all those 5 factors in the initial pleading. But otherwise, if somebody just does their best and explains why they think they should have contact with the child, they're going to get a hearing. And then they'll hear what the complaints are, and then they can come up with responses to why they do meet all those factors. Just like people do their best when filing their pro per documents, and sometimes the court helps them out by saying, well, you're going to need more in this area.
And would you say that this is like a low risk area? So if a paraprofessional gets it wrong, just like an attorney can get it wrong, what can happen? What's the
Okay,
worst case scenario?
for the JV 180, there is a risk. Actually, I think anytime there's a dependency case open, there's a risk. This is almost life or death material. Subject. We're talking about people losing their children forever or losing contact with a child forever. So when Fariba first said, how could paraprofessionals help with dependency? I'm like, no, don't do it. But then I began to think, if somebody is really good with their boundaries and knows not to give legal advice, and they're just putting down facts, I think it would be they'd have to get some special training. They'd have to understand the risks. De facto parent requests can get really heated with arguments and briefing. And I just had a really long, contentious, almost trial on a de facto parent request. So it's not to be taken lightly. Most of the other forms giving information to the court, there's really no harm. And how to fill out the forms to get access to records, I don't see any real risk there. The worst that can happen is you get turned down because you don't qualify.
Sorry, one last question. I feel like I'm hogging the floor, but this is all very interesting and great information. And once upon a time, I clerked for a dependency court judge, and yeah, like those are very intense cases, life and death, and it's kids' lives that we're talking about. What is your opinion on whether paraprofessionals in these scenarios should represent in court?
Can you say that again? A paraprofessional?
Represent a client in court in these proceedings.
I didn't know that a non-lawyer could represent.
So there has been some development. Let me bring you up to date. We just had our meeting last week. It seems a long time ago, but was it last week? Anyway, so the full committee voted on allowing full in-court representation and left it up to the subcommittees, so specialized subcommittees, to determine they're going to opt out of that default position. So that's why we're discussing it. And we as a committee could vote on not allowing in-court representation, as a group. And there's various options like full in-court representation, sitting at the council table and responding to judge questions, and then sitting at the council table, but just assisting the client with forms and kind of, oh, here's your exhibit, things like that. And then sitting inside court, but quiet, like a support person, or just not coming into court at all. So the full group had all those options, and they voted for the full in-court representation as a default position. But then again, it's now up to the subcommittees. That's what we're going to discuss it today. And I know we caught you by surprise, but do you have an opinion? And I believe we voted that paraprofessionals can give legal advice.
Okay.
I'm not sure if I voted on that, but that's definitely on the table.
So the question in court, my first thought is no, but not necessarily for the reason that you think. Every other party in court at the table will not just have an attorney, but a skilled attorney, because you can't just go in. I mean, family court, anybody with a bar card can go in there and say, I'm an attorney, and they might not know what they're doing. And there also might be self-represented people on the other side. So if there's a self-represented litigant and then somebody who brings in their paraprofessional, it's no harm, no foul. But in dependency court, you can't appear unless you meet certain requirements. Now, for appointed counsel, you have to have the requirements. But if somebody comes in with an attorney that the judge doesn't know, that's not known in that system, because it's a very closed system in every county, and says, I'm representing so-and-so, I'm a criminal attorney, I'm a family law attorney, I come in, the judge will give a caution to the person who brought in the non-dependency attorney to say, you're taking a big chance here, you're going to waive your right to an appeal for ineffective assistance of counsel. You have the right to court-appointed competent counsel if you want to go forward with the person you brought in, it's on you. They really try to scare them. With good reason, because somebody who doesn't know their dependency law can do terrible damage. So that's for the people who are entitled to appointed counsel. Even people with money are entitled to appointed counsel. And that's an interesting side. So for a non-dependency attorney to go in is dangerous. For a non-attorney to go in and appear there is really dangerous. It's a narrow but complex area of law, and the stakes are everything. So my first thought is it's too dangerous.
Okay, I know Linda has a question, but let me just do a follow-up here just to make sure I'm understanding you correctly. So in certain situations, there's a right to court-appointed counsel, and I believe it's my position's best course, I agree with you, is not to bring in a paraprofessional or just go with your court-appointed attorney unless you want to bring in private dependency attorney. That's totally up to you. What about when there's no right to appointed counsel? If I understood you correctly, when a JV 180 is filed, there's no right to court-appointed counsel. And when a de facto parent application is filed, there's no right to appointed counsel until after they're appointed.
Right.
Or it was granted, sorry.
Yeah.
So in that state, do you think it's better to have no support whatsoever and go in just by yourself, or would it at least be helpful to have a trained paraprofessional? Because remember, this comes with training. I mean, there's an education subcommittee that's already looking at that and everything, okay? And there's CLE requirements, just like attorneys and everything. So do you think it's better for the self-represented litigant to be by themselves in those very limited circumstances where there's no right to appointed counsels versus at least having a paraprofessional?
You know what? I'm flip-flopping right now because it's the first time I've considered this.
Yeah, welcome to the club.
and I do see that a skilled paraprofessional at least knows how to address the court, knows when to speak, knows how to pay attention to what's in order and what's just talk. And that's valuable. Just in saying, shh, no, we're listening now, and knowing how to respond when the court asks a question. So a skilled paraprofessional is probably at least as good as the worst courtroom lawyer. Right? We see lawyers who don't know how to behave. So now I'm thinking, that's definitely worth looking into, definitely worth considering. I'd have to like think about it and go to court and watch a little bit and say, what do the self-represented people do? Usually their mistakes are that they don't know how to behave in court because they've only seen people.
I think especially in these cases, based on what's involved and the type of functionality level we're looking at here, right? Okay.
Right. People whose lives are in trouble.
Exactly. And they're traumatized. I mean, it's hard to, the emotions are high. So hang on just a second. I think Linda had a question and then Dana. Oh, not Linda?
You brought up the question that I was going to raise.
Okay.
Thank you.
Okay. Dana.
Thank you. Mary, thank you so much. What I'm really appreciating about you is you're grappling and weighing right now in front of us. And I think that's really helpful. So I did dependency work for a couple of years, but mostly I supervised a dependency team for 20 years in Santa Cruz County. And I have strong opinions about this. And I agree with what you said about the way I used to describe it was, this is the worst, having your children taken from you is the worst penalty that we provide as a society in civil court. To me, it's akin to the death penalty in criminal court. Incredibly serious. I have strong opinions about this topic. And what we had voted on preliminarily was we would allow a paraprofessional to assist prior to the first court hearing when counsel is appointed, because they can help with things like a safety plan. They might be able to avoid a detention hearing or removal. And then we would allow the 180s after the conclusion of the dependency, because as you say, that form is really geared for non-attorneys to complete. Now you've added for our consideration the issue of the de facto parent, which I think is interesting. But for all of that, the part in the middle, we had not contemplated allowing paraprofessionals to represent parties who otherwise are going to get counsel appointed. And I hope we do not stray from that.
I have a response to that. And as Fariba did say, what about before filing? So there's something that I've learned now that I'm in private practice and people call me when the social worker first contacts them, or they call me when something has happened. When I was just working for the dependency firm, first I'd hear about it, petition's filed, I get it the night before, and I meet the client the first day of court. But now I have people who call me and say, something went down and a social worker's made an appointment to come to my home. What do I do? And so I explain to them what the standard is, how to cooperate, what they have to share, what they don't have to share, what they might do. And on a couple of occasions, I've gone with them to the social worker's office to meet with them, and there hasn't been any dependency case filed. And back when I was, a staff attorney, I thought I would never be permitted to meet with a social worker without county counsel present. But if there isn't a case, they actually permit it. So I've been a great help to my client who has a nasty family court case, and then somebody made a CPS referral, just in being present while he's being interviewed with a social worker, in case I can tell that he's not making himself clear or the social worker's missed some point, I can step in and help. And I'm very courteous. I don't want them to say, okay, I don't want to be accused of the attorney who comes in and bullies the social worker, but it's helpful. And then with the safety planning, with telling them when they go to meet the social worker, what they should have to show, what the social worker will be interested in. And so those tasks, you don't have to be a lawyer to do those, now that you're thinking of it. So I know that the Dependency Advocacy Center just received some sort of grant because they're trying to create some pre-filing assistance, identifying families that may be subject to a petition, and then applying their in-house social workers or applying an attorney to advise them, here's how you can avoid having the petition filed. This county really prides itself on its differential response and its ability to not file if possible. Now, sometimes you have to take the child out of the home, but if it's, there's some alcohol use, there's some DV in the home, social worker goes out there, gets the parents to agree to, voluntary services for 6 months, they never need to file. It would be helpful if somebody facing that could talk to a lawyer or a paraprofessional who says, yeah, you should do that. Here's why. And yes, that's advice, but it's advice I give people all the time. Cooperate with a social worker, agree to do the classes and services and testing, and then in 6 months they'll go away. And if you don't do it, they'll be back with a petition.
Okay. Steve?
Well, thank you. So with the de facto, I really appreciated the chart. So I dabble as little as I can, Mary, in dependency court because I'm a family law attorney. I'm usually dealing with exit orders and modifying them in family court after the fact. Right. So the one area that I'm really interested in is when we're dealing with de facto parent claims, grandparent claims, sibling claims, because those individuals aren't entitled to court-appointed counsel. But the child who's the subject and under the jurisdiction of the dependency court does have counsel. And it's been my experience that they will weigh in if there is a non-parent relationship that needs to be protected in order to get an order that's in the best interest of the child. Do you think that currently the work by the appointed counsel for the children is adequately addressing this need to have third-party relationships? Or is there going to be some benefit to these individuals being able to advocate on their own?
I don't think it's adequate. The children's attorneys can only assert relationships that they know about. And sometimes the only way they know about it is because the social worker for the county told them or not. When somebody comes to me and they talk about their, my grandson is in foster care and I want to see him. And the first thing I do is I say, have you contacted the child's attorney? And sometimes they don't even know how to do that. And so I can refer them over to, the agency in this county that takes care of that. I say, that's where you start. But if they don't present real well, or they're all angry, or they're still in that, nobody should have taken my grandchild, I should have them. It's better probably to have a paraprofessional or an attorney reach out to the minors counsel. But minors counsels aren't able to find all the relationships. And also sometimes the child is small and they don't know who that person is, that they would recognize if they saw them, but they're not going to say, I'm missing, auntie.
Okay. And so I get a buffer role that could be very helpful in terms of preserving that relationship that the minors counsel otherwise wouldn't be aware about. with regards to the pre-filing assistance. So that would include getting copies of any of the reports which parents now have a right to get that did not result in a case. Okay. I think that's one of the areas where we've already agreed that that's would be an important benefit, so that people get some assistance as opposed to no assistance because they can't hire counsel. So can you think of any, besides meeting with the social worker and obtaining any pre-existing reports, can you think of any other pre-filing services that people could benefit from that we haven't talked about yet?
I'm just sort of pulling these out. Gathering their medical records and schooling records to make them available to the social worker, because sometimes social worker goes out and they say, you know, all we heard is that you're not getting your kid to school or your kid's not vaccinated or whatever. So just the practical aspect of assembling the documents that they should provide to the social worker, or getting them together so when they take them into the office, they've got them. Many times I'm reading in social worker reports and they say, you know, the mother, you know, says the kid was vaccinated but had no records of it. And so then the social worker has to go track down the doctor's records, and the more work the social worker has to put in, the more at risk people are of them escalating it.
Oh, thank you. I really appreciate your work.
Thank you. I see we're at 12:20, Linda.
Yes, and I also note that there is someone, there's an attendee who wants to speak. I just wanted to mention, Stephen, you asked if there were any other tasks. And what we've been doing with some of the other subcommittees is moving away from having an exhaustive list of every single task that would be authorized, because of a concern that we might miss something. And then you have a paraprofessional saying, am I allowed to do this? Am I not allowed to do this? And if it hasn't been listed, then there's that risk. And moving towards more like you can provide representation, except in these things that are excluded. And so it might be, in terms of the child welfare cases, we can say that they can provide assistance pre-filing, you know, to people who are entitled to court-appointed counsel. They can provide pre-filing assistance for during the time and when they're not entitled. They can provide assistance after the case is closed, and they can provide assistance to people who, during the pendency of the case, who otherwise would not be entitled to court-appointed counsel. That's an approach, rather than trying to make sure we capture
the laundry list like we did in family law.
Yeah.
And Madam Chair, I'd make a request that we defer any public comment until all of the speakers have spoken, since we did take public comment at the beginning of the meeting.
I wouldn't mind. It's just that if it's about Mary's topic, I think it may be helpful to do it now and keep the conservatorship comments, because I don't, you know, Mary may be able to help answer or comment, versus waiting until after conservatorship. So would you mind if the public comment is about what we're talking about, I'd like to take it now, if you don't mind. Would that be okay? Acceptable?
You're the chair.
Yeah, I'm overruling you, Steve. No, I'm just kidding.
I did not want Ms. DiPello to have inadequate time to present on the issues of guardianships and conservatorships.
Of course.
So Fariba, do you want to limit the amount of time for speakers?
Yes, 3 minutes. Yeah. How many do we have? Just one?
We have, well, right now we have one. I guess the other person has lowered her hand, maybe because of this. So I'll invite Minyoung Lee.
Okay. Yes, Lee.
Oh, thank you so much. My name is Minyoung Lee. I'm a family law attorney from Neighborhood Legal Services, but prior to my time at Neighborhood Legal Services, I practiced as a parents attorney in Los Angeles County in dependency court for 8 years. And so I really appreciate your presentation, Ms. Feldman. I think it was really comprehensive and really described very accurately what happens in dependency. And so for this committee, I am really urging really the sentiments. I like to echo some of of the sentiments of Ms. Feldman and also of Ms. McRae that, dependency is such a specialized field. And it really, I have seen time and time again in my years in dependency, attorneys, private attorneys who are paid very, very good money come in and really just not be able to do dependency. I mean, they can have the most excellent qualifications in family law, but really it's so specialized that unless you're really in that world, it's so hard to understand how to interact, even in the most basic functions. And so when this committee is considering things like even pre-investigation, Ms. Feldman, in LA County as well, there are parent advocates groups where parents have gone through the dependency system who are then able to provide peer support for other parents who are now involved with DCFS in the investigative stages. And I believe that those kind of peer advocacy groups are way more helpful, because even a paraprofessional who may have training in the books and in the law, really, unless they are interacting in the system on a regular basis, is really not going to have a full understanding of the impacts and really the ramifications, even in a pre-investigative stage, of how that could affect this family. And so I caution, and I'm asking this committee to really caution, even things that that's been considered that are maybe where court-appointed attorneys are not yet involved, that it really does require a level of understanding of how the system works, and to just ask for consideration for other groups like peer support advocacy groups to maybe take and fill in that role instead of having paraprofessionals do it. I would agree that filling out forms is helpful, but anything that requires court representation, I'm asking this committee to really urge to stay away from it. And
30 seconds remaining.
Okay, sorry. And so last comment is that when you're talking about other groups who are also not entitled to court-appointed representation, please understand that they also don't have standing. So even if they were to bring in private counsel or paraprofessionals, they may be welcome to sit in the back, but they would need the court's permission to even be able to allow their paraprofessional or their attorney to speak during the hearing. And so I would just really ask this group to consider some of these things. Thank you.
Thank you. Mary, did you have any comment on that?
What Ms. Lee said is exactly correct. And I forgot to mention about standing. I have gone with, even as a full child welfare specialist attorney, I have gone with foster parents to court and not permitted to speak or be at the table because they don't have standing.
Okay.
But I can help interpret what's going on in court for them. So educated ears can be helpful to an individual. Yeah.
I kind of find Ms. Lee's comment interesting, that she believes that it's better to get help from the peer groups rather than a paraprofessional because they have regular interaction within the system. What do you think about that?
I think that having regular interaction is critical. And I've even noticed since I'm not doing it every day now, about a quarter of my caseload is dependency. So every week or so, I might have a dependency hearing, and I'm already noticing that I'm not in it on the daily basis with the players that are there, with the courts. And I think it's so important to know the system you're in, that I don't even practice in other counties. I mean, I've gone into Santa Cruz County and Merced County a couple of times, but I don't even want to do dependency in other counties because of the local situation is so different in each one.
Right. So it may be something for our education committee to take a look at for consideration. So thank you so much. I got to get my other expert, Carlina Tapella, on. You were fantastic. I think we all agree on that. Thank you so much. And I hope we can reach out to you for follow-up questions, right?
Oh, sure. I'm going to listen in because I want to hear the rest of this. This is fascinating. I had no idea.
Thank you so much. Thank you. All right. So I'm also delighted to have another expert here. She's going to talk to us about conservatorships. This is Carlina Tapella. Do you pronounce the L's or no?
It's my husband is Italian and he pronounces the L's.
All right. Capella. She's of counsel with Weintraub Tobin in their Sacramento office. She's in their firm's trust and states practice group. She, as part of her work, of course, she does guardianship, conservatorships. I had a really good conversation with her yesterday, and I think she could give great input today to us, especially in the area of conservatorships, the various tasks we've already listed, and make sure we haven't missed anything. Also, I'm hoping to get her comments on in-court representation. She is on the Trust and States Executive Committee of the California Lawyers Association, and she chairs as the Education Committee. She's the chair of the Education Committee, so that tells me she's an expert in the applicable law as well. Welcome, and we've sent you the task list, so I want to just give it over to you for your comments.
Thank you. I wished I had a beautiful PowerPoint, but Fariba and I just spoke yesterday about what you really wanted me to present at this meeting. And I'm working from the conservatorship and guardianship knowledge and tasks list that I received. And I just want to give one little bit of an overview about conservatorships. And I've done hundreds of conservatorships over the years. There are three types. There's a general probate conservatorship, which is generally for older people. Second, there's LPS conservatorships, that's mental health, that's Welfare and Institutions Code. And then there are limited conservatorships, which are for developmentally disabled adults. And in my experience, where I have seen the most need might be in limited conservatorships. Where I see people self-represented, they'll go in and get a limited conservatorship for the developmentally disabled now adult child. This is one area. I will say also that there are a lot of attorneys who just will not touch this area. It is very paper intensive. Even just to start a conservatorship, a general probate conservatorship or limited, you're going to have to fill out almost 25 to 30 pages worth of information. And it's not the user-friendly form that Fariba had was talking about with respect to the juvenile court. It's not user-friendly. It's for attorneys to fill out. And if you're going to add on top of that a temporary conservatorship, because you have a temporary conservatorship until the court would consider the petition on the general or permanent conservatorship, you're adding in another 10 to 12 pages. So you can have your first initial conservatorship filing this much paper. So Fariba did tell me that there was a determination that estates, because you can do a conservatorship of the person, which is food, clothing, shelter, medical, or a conservatorship of the estate, which is managing finances. The one thing I also view the conservatorship area as different is you're appointing somebody who's making decisions for another person. And those decisions affect that person's civil rights. Taking medication, you can force people to take medication, undergo medical treatment. You can force people to undergo medical treatment, even if they don't want to. You can make a decision where they live. And with court order, you can make a decision who sees them, visits them, what mail they get. So it's different. I do not do family law. I'm just saying, like in family law, that person is directly involved. But in conservatorships, you're acting on behalf of another person. The other thing as well is that in conservatorships, the person is entitled to a jury trial. That's the one area in probate law where an individual has the right to a jury trial on, number one, whether a conservator should be appointed or who should be the conservator. And practices differ from county to county as to appointment of a conservator. If it's not just somebody else, you have a child goes into court, seeks conservatorship of their parent. Usually the person who's going to object is going to be another child. You also have, in this case, always the person who is the proposed conservatee. That's who you're trying to get the conservatorship over. The court investigator goes out and talks to them. And if they get out the words, I object, I don't want a conservator, and I want a jury trial, you have opposition. Now, some counties will say, well, the conservative objects, but I see all of the evidence here in the petition. I'm going to grant the conservatorship. There are other counties that say, once that's stated by the proposed conservatee, I object, that person, you're going to go to trial on it. There's going to be an evidentiary hearing on whether a conservatorship is required or not required. And if they get out the words, I want a jury trial, it's going to be a jury trial. And with every one of those, like the appointment, you can have discovery, all types of civil discovery, interrogatories, whether it's person, whether it's a state, or whether it's person and a state. So if you have a uncontested conservatorship of the person, then I think that a paraprofessional can assist with completing the forms. My experience, and I do different counties throughout the state, has been the court is generally really helpful in kind of guiding the conservator, because they'll post probate notes. And so they know, well, you didn't personally serve the proposed conservative with a citation, or you didn't give notice to this individual, so you have to correct that. You didn't have this particular form. One thing, you have to have doctors fill a capacity declaration. And sometimes the doctor says, I'm not going to fill that out, especially if the conservative says, don't give them any information. You have HIPAA concerns, right? So I think that if you have an uncontested conservatorship of the person, attorneys need assistance filling out those forms. That's why they just don't do them. I think that might be helpful to the general public, especially with a limited conservatorship, because most of the time in a limited, which is developmentally disabled, the conservatee is not going to object. They're at a level where saying I object to it is just not going to happen. And the other advantage is one other factor to consider in limited conservatorships is there's always court-appointed counsel. And so when you have court-appointed counsel in a limited conservatorship, that person can kind of assist with moving things along, right? So that's one area. Now in conservatorship, general probate conservatorship, anybody over 18, for whatever reason, not because they're developmentally disabled, but they might have had a stroke or whatever, dementia is usually the most common one. The court can appoint counsel if the court finds that the appointment of counsel will assist in the resolution of the matter, but it's mandatory if the court investigator goes to talk to the conservatee, and they have to ask them a specific set of questions. And one of the questions is, do you want an attorney? And if they say yes, the court must appoint an attorney. But a lot of times what the conservatee will say is, I don't need any help. I can make my own decisions and I don't want an attorney. So, but the court may consider, after reading all of the interviews that the court investigator does, that it still might be helpful to the court to resolve the matter of whether a conservator should be appointed. So that's kind of the overview of conservatorship of the person. The one thing I did notice that wasn't in the list was, well, what if I need a temporary conservatorship of the person? What if for some reason there's a medical issue and the mother doesn't have an advanced healthcare directive, which is what is commonly known as a durable power of attorney for healthcare, right? She hasn't designated anybody to make medical decisions, and the hospital is saying, we need someone to make a medical decision. Unless you have granted somebody else that authority, you have to go in for a temporary conservatorship. That's a little complex. There are rules on notice. I think, maybe somebody could do it with training, but there are rules on notice. You have specific forms that you have to fill out. You have to make a determination as to whether it's an emergency or whether you just feel like you want, mom's living in a hoarding house, right? Mom's a hoarder, and but is she really in danger, right? Is she really in danger? Now, I can give you examples of cases where the person, there were rats in the house. So then you say, yes, I went to the house, I went to visit, and there were rats in the house. So even though the person has been living that way for 2 months, is it really an emergency? The court's going to exercise its discretion, but that's a whole nother packet of getting an ex parte appointment of a temporary conservator of the person. So that's limited, that's general. Oh, the other thing that's unique, I think, about conservatorships is they can go on for 30 years, 40 years. They can go on for a long time. It's not a closed proceeding. The case is never closed until the conservatee dies, or for some reason, the conservatorship is terminated. That happens infrequently, but an example is somebody has a stroke or has an injury in an automobile accident and can't make decisions, but then they recover capacity, meaning that they recover from the accident, they recover from the stroke, and the conservatorship gets terminated for that reason. So it is an ongoing process, and you have to keep track of, you know, over the years, what needs to be done. There are certain things that do happen after a conservator is appointed in the conservatorship of the person, which is really just form filling. You have to give the conservatee notice of their rights. It's just filling out a form. There's no court hearing. It's just a form that's mailed out. You have to file with the court a determination of the conservatee's appropriate level of care. Where were they living when it was established? What's the plan in the future? Again, that's just a form that's completed. It's filed with the court. There is no hearing. Potentially, there could be a petition to fix the residence outside the state of California, which is the same thing in guardianships. And I think they even actually use the same form. And that does require a court hearing. And anything that you file as a petition, anything that's filed as a petition could be objected to, right? And then it becomes an evidentiary hearing. Another one would be a petition for a specific medical treatment. So for example, I had one that was an experimental drug, right? The person had a medical condition, and you can't give experimental drugs without a specific court order. So there's a specific provision in the probate code which allows you to go into court and have the court determine whether the person can undergo experimental drugs. Usually they will hold an evidentiary hearing on that, because you'll have the physician testify as to why that might be necessary or why that might be helpful. Other times, this does not happen very frequently, and really is, I'm just going to say, is in the realm of really experienced conservatorship lawyers. Another one is end of life decision making, right? The conservatee has not left their wishes, and the family is at a situation where what's the decision that's made, and you got to go to court and have the court make a determination as to end of life decision making. The other area that comes up in conservatorship of the person, and that's what I'm just talking about here, is to transfer conservatorship proceeding to another state or accept a transfer from another state. And I was just involved in a case. I was court appointed counsel, and it was a transfer from Oregon, and the sister tried to do it herself. And really it was very complicated, because you then have to go look at Oregon law. And under Oregon law, they're what we would call a general probate conservatorship incorporated mental health placement lock facility. Can't do that in California unless you have an LPS conservatorship. And so you couldn't do the transfer, but you would have to know that. You'd have to know you have to go to the law of the other state to determine whether it can be, it's a transfer. There's no, the laws are quite similar, right? But you can't do the transfer if it involves mental health. LPS conservatorships, one area potentially, LPS is mental health, and the law is that conservatorship lasts for a year, because the hope is that the individual gets treatment, either medication or intensive treatment in a locked facility. Most of the time that's renewed every year, but family members, it's all initiated by county council. You can't initiate them yourself. It has to be done through county council. They do the first initiation of an LPS conservatorship. But sometimes if there's a family member available, they will petition for that person to be the LPS conservator of the person. And then when the year comes around, you can do a petition for renewal of the LPS conservatorship if it's supported by declarations of two physicians. And that's just a document, right? That I'm going to say that's just a pleading. It's not a judicial council form. It's a pleading that one does. And I think perhaps a paraprofessional might be able to assist in that. Because if you've got the supporting declaration of the two positions, it's generally going to be granted. And also in LPS conservatorships, the conservatee is represented by the public defender's office in most counties. Most counties use the public defender's office. Some counties will use private counsel. It varies from county to county. For petition, I was looking on the list, and a petition to remove a conservator. What I would say is a petition to remove a conservator, 95% of the time that's going to be contested. That to me is an adversarial proceeding most of the time, because either if the conservator is thinks that they're doing things correctly, they're not going to resign. And so that's putting someone into the position of having to remove them, right? Now, resignation, the one thing about the resignation of a conservator is then you got to get somebody else appointed. So you can do a petition to have the conservator resign, but the court's got to keep it on its plate, because then who's going to take, it doesn't end the conservatorship. Somebody else has to be appointed, because the court's already made the determination that a conservatorship is required for this individual. So in that circumstance, if it's just a petition to appoint a successor conservator of the person, I'm resigning because I'm moving to Massachusetts and I can't be the conservator for my mother any longer, but my brother who lives here can do it. It's just a simple kind of a transition, but it involves two petitions: resignation, appointment of a successor. So that those are kind of all the things I looked at on the list having to do with limited and general and LPS. I will say one thing about a general conservatorship: as many as I do, the fraction of people self-represented in a general conservatorship, percentage is small, maybe 2 to 3%. People don't represent themselves. One other thing to consider in conservatorships as well is you can get, if you have an attorney, your fees can be paid upon court approval. So that's why there's a fund, which is the conservatee's Your Mom's Money, available if you go to the court and you say, I need conservatorship. I'll use the first example that I used. My mom needs surgery. Okay, we're going to grant the conservatorship. I can petition the court to say, Carlina Tapella assisted me in this to get the conservatorship. I'd like her fees paid from my mother's funds. And the court has discretion. They have all these factors that they have to weigh. It doesn't mean it's a rubber stamp. They look at what's the reasonableness of the fee. Someone can say, it took me 25,000, and I could say, wow, I do that all the time, it took me 5,000. But so that kind of eliminates perhaps the need that somebody doesn't have the access because they can't pay an attorney, because the court may say, oh, you can have your fees paid from the conservatee's funds. That's all on conservatorships. Like I said, it's very form intensive. Most every petition that you file, you're going to go to court for, except for those 2, 3 that I mentioned. I'm sorry, no, I just forgot this one. Before you move a conservatee, you have to do a pre-move notice that you give to second-degree relatives. Those are the people generally entitled to notice in conservatorship proceedings, so that they can object. And if they object, they can go to court and say, I want the court to determine that the placement can't be changed. So that's going to be adversarial, because you've already got someone who's filed the notice that it's going to be changed. And then after you move, but if you have no objections, it's just a form that's filed, letting the court know and the secondary relatives know this person's going to be moved. Then once you do move that individual, you have to file a post-move notice of change of residence, because sometimes something may have happened in between the pre-move and the actual move that the move never happened, right? If there's an illness or some reason their level of care increased. So you have to do the post-move, and that's just a form that's filed with the court.
Okay. Thank you. Wow, incredible. I just wanted to, at the end you said, so for most, all of the proceedings or the paperwork or the petitions, the court hearing is going to be required. Now, it may be uncontested
Yes.
or contested, but definitely a court hearing is required, right?
Always on a petition for, well, you can go in ex parte for a petition on a temporary conservatorship, but those require additional forms. So, you know, different counties have a different procedure. In Sacramento, you go before the initial hearing, you submit it, and then you're heard at the end of the calendar, but you are still before the court, most definitely.
And you said something about 2 to 3% of the cases are represented. Did I hear you right?
In a general conservatorship, I would say it's very, very few people are self-represented in a general conservatorship. I see more in a limited conservatorship. And usually it's because the Alta Center, whatever you have, the regional center in your area, they will say to the parents, now, you know, your child's going to be 18 years old, you need to go to court and petition for a limited conservatorship. And so the parents will do that. And it's usually person only because the child doesn't have an estate, which is money that needs to be managed. You request 1 to 7 powers that to be granted, and then to be denied to the conservatee, there is court-appointed counsel. That's the most frequent type of conservatorship under the probate code that I see self-represented parties.
Okay, all right. We are at 12:47. I want to see if there are any questions from the members for our speaker.
Hi.
Dana, and then Steve.
Thank you. That was really very, very helpful. My question is, if this group were to allow paraprofessional representation for limited conservatorships, do you think that with the proper training, they could appropriately make these cases to a judge?
I think yes, my answer would be yes in a limited conservatorship, because that is really filling out forms. That's just filling out the form saying why you need the limited conservatorship. The court is going to be guided by what is the report from the regional center. So the regional center will come back and they have to address each of the 7 requests and make a recommendation. The court is not bound by that recommendation. You know, unless the person is, for example, severely autistic, severely developmentally disabled, 1 or 2 powers, Alta generally will recommend deny, which is social contacts, social and sexual, that's 1, and the right to get married. But you usually can, if I'm representing a person, I say, well, they might be 18 years old, but they have the mental ability of a 5-year-old. And the mental ability of a 5-year-old cannot determine what's appropriate sexual and social contacts, and cannot, you know, enter into a contract to what are the legal rights of being married. The one thing about limited conservatorships, it's different from a general conservatorship because the conservator is obligated under the law to foster independence if that's appropriate. So yes, to answer your question, I do believe that a limited conservatorship is something that a paraprofessional could do with training. Rarely does it go to trial unless you have the individual who says, I don't want my mother to be my conservator, but because of that person's disability, that really generally doesn't happen. Did that answer your question?
Very well. I appreciate it.
So I'm on mute and I'm talking and say, Steve, talk.
Okay. I was writing. I had to wait for permission. All right. So Carlina, what do you think is the amount, what education would a paraprofessional need to deal with the limited conservatorships, and how many hours do you think they should be studying, or we're calling it experiential hours, the amount of time that they're going to have to work under an attorney and be supervised by an attorney prior to being licensed? Can you give me an idea of like educational things that you think would need to be specifically addressed, and also the amount of time that they should work under an attorney that works on limited conservatorships before they would be prepared in your opinion, to navigate this?
Okay, so if I look, preparing the paperwork, that's just something it's form. It's just, they're just forms. So you'd have to learn how to do that. And I guess I would say going through a whole packet for limited conservatorship, maybe you could go over it and explain what everything means. Steve, I'm just doing this totally off my top of my head, maybe 5 to 6 hours. But I think that there has to be some education to train about the concept of what is a limited conservatorship. What's the role of the regional center in a limited conservatorship? What's the role of court-appointed counsel in a limited conservatorship? And I think probably what you do is you'd want to have the person, I think hands-on experience is better than book experience, you know, that they would have to work with an attorney to assist or be mentored or intern with, say, 5 limited conservatorships or just some number. I think rather than the number of hours, do a case from start to finish. To when the conservator, the individuals are appointed as the limited conservator. Once that has happened in a limited conservatorship, what happens after that is you're just going to get, I don't say just going to get, but you'll get a visit from the court investigator to see how things are going and make a report to the court, because you don't want someone to be appointed conservator and they die and the person's left unattended. So, and after that, I don't think that there even needs to be, I don't usually stay involved, right? If there's a problem, the clients will come back to me, but usually it's just the court having the investigator do a report, come back to the court, and there be some determination as to whether there should be some follow-up. But I think the best training is hands-on and experiencing what's an ALTA report look at. You look at IEP, which are, you know, educational plans. What does that show? Are the parents, you know, you have to explain to, it's usually the parents, right? You have to explain to the parents, you have to foster independence. So you can't keep your child at home, your adult child at home, without exploring possibilities for employment, possibilities for educational. And there are degrees of the person's disability. Some it's profound, and that's just not going to be, that's just not going to be appropriate to make educational decisions. It's just not available. But medical decisions, that's where, you know, that's where it comes in most often, is because that person's still an adult. They're 18 years old. And even though they're impaired, they have the right to make their own decisions. And until a court determines that they don't have the right. So you have to have that understanding of, you know, the degree of the disability, and when you make the request, what supports the request? What is supporting my request to be granted the powers to make educational decisions, or what do you need to support accessing the confidential records of the individual? So that's why I say maybe 5 would give somebody a really good look at what it takes to get a limited conservatorship established.
And what I'm thinking from what you said about the education, maybe like a 1-unit course, which I think is the equivalent of 14 or 15 hours of class time that dealt with concepts as well as the forms and kind of overlap the two. And I know it's not a substitute for really doing it, but we need to have some kind of educational component, I think, if we're going to allow conservatorships to be done by the paraprofessionals. It seems like a 1-unit course would be sufficient to address what
on limited conservatorships. Yeah.
Yeah.
Yeah. And then you are also going to have the assistance of mandatory court-appointed counsel, who's going to look over all of those powers themselves. And they may say, you know, I think my client should retain their power to have social and sexual contacts for whatever the reason, or the power to marry. Like I said, those are the 2 big ones.
Gotcha.
Okay.
Excellent. Thank you, Carlene. I appreciate it.
Any other
you.
questions for our guest speaker? Okay. Thank you so much. This has been so helpful. Both you and Mary really informed us greatly today. Are there any public comments on this part of the presentation?
It looks like there is a public comment.
How many?
Just one at this point?
3 minutes is 12:50. Well, 2 minutes because it's 12:56.
Okay, let me just go ahead and have this person start. This is Karina Alvarado.
Ms. Alvarado?
Hello there. Can you hear me?
Yes.
Okay, perfect. So just wanted to chime in. I'm an observing member of CALDA, the California Association of Legal Document Assistants, and just wanted to provide a bit of information about LDAs. Right now, LDAs already have the ability to fill out and file paperwork for limited conservatorship. The office I work at in Contra Costa County, we do assist with everything but the court hearing. So I think that allowing for a paraprofessional to assist with the client with court representation in a limited conservatorship would be helpful for clients to feel comfortable with the entire process. Right now, it's something that LDAs don't have necessarily a one unit course that they need to train in. It's a matter of learning within your place of employment, or with some of the NOLO books, for example. But it is something that is within the scope of LDAs currently. So I do think that it would be really wonderful if LDAs could get this training in order to assist with the full process here. That's all. Thank you.
Thank you very much for your comment. Any other comments? No?
No, oh yes, there is. There's one more speaker. I can go ahead and allow her. This is Angela Grijalva.
Perfectly stated, thank you. So I specialize in family law here in Sacramento County, but as I was watching, and listening, it seems that there's the common threads in this area of practice of juvenile dependency. It's a lot of form-based, and once I guess the practitioner, and as I had to go through as well as a local LDA, once you get familiarized with the local unwritten rules, you can really help the clients navigate through the dissolution process. And that seems to be the case for juvenile dependency because it's so specialized, and the conservatorships as well. But I appreciate the prior public comment. At CALDA, I think, and one of the speakers spoke to having very strong boundaries. One of the things that makes CALDA's MCLEs different is not only they teach the classes with keeping in with not practicing law, and providing and steering clients to resources. Instead of you being the source of information, you use a self-help published resource as the guidance for the client. And so I think if the paraprofessional would be able to practice law, I think having the resources available would be better for the public. And I think LDAs are doing it right now successfully, regularly, not just the limited conservatorships, but other the more complex ones, because the pro-pers are doing it on their own and they're lost. And you're right, there are little niche communities that they support each other. And so it's happening now, whether this profession has been
30
established.
seconds remaining.
Thank you so much.
Thank you, Ms. Grijalva. Okay, we're coming up on 1 o'clock. I want to respect everyone's time. Thank you again, Carlina and Mary, for your input today. It's been invaluable. I think, Linda, we're just going to have to kind of meet again in May to discuss, the results of what we thought about the presentation today and kind of make our final decision. Yeah.
Well, I think the plan, we were hoping to get the recommendation
For April.
for the April meeting on, what's already been decided on family, as well as conservatorship and guardianship, and to revisit the recommendations.
Would have
for
to be next week. Yeah.
Well, we have no, our meeting is scheduled to go till 1:30.
Oh, I'm sorry. Okay.
Yes.
Okay.
So I think we have time to discuss and come to a decision, hopefully.
Okay, I'm sorry. I thought it was until 1 o'clock. My apologies. Okay.
Well,
Yeah.
I have a hard stop at 1:30, which means the meeting does, because I have another
Because we
sub-
have a regulations
starts
meeting
at
at 1:30. Yeah.
That's right, and you do too, Fariba, yes.
Yeah. Okay. I will require just a few minutes to take a quick break, if I may.
Sure.
Justice Petro, I just saw you. Did you want to make a comment?
No. It's fine. I think a 5-minute break is a smart thing.
Okay. Let's do a 5-minute break and regroup at 1:05. Thank you.
Do you need
you.
us to, do you need me to stick around? This is Carlina. Do you need me to stick around?
No, both you and Mary, thank you so much. You're free to go. We really appreciate your presentations. Thank
Thanks,
you, Mary.
Carlina.
Thank you, both of you.
Thanks, Mary.
Thank you.
Okay. If everyone could turn on your camera, just I want to make sure everyone's here. Okay. Is Dana, Sharon, are you with us? Okay. Guess we can get started. She'll join in. Okay, so this, for the next half an hour, we've got to talk about what we want to do, include with guardianships and conservatorships, and I really want us to talk about in-court representation too. Now, Linda, with regards to the list being limited to those tasks and issues that paraprofessionals can't cover, right? Is that what we're doing?
Well, I don't know that yes, I think that's an alternative way, and I've just drafted a similar recommendation in, actually it wasn't, I haven't done the recommendation yet, but in the housing subcommittee, we came up with more of an exclusionary that they can do everything except for this and this. And I think, again, the concern is if we try to come up with the exhaustive list, there is a risk that something might inadvertently be missed.
And the list is huge for conservatorship and guardianship. So it
Right.
makes sense to me. If the list of things they can do is longer than the list of things they cannot do, then we really should go with what they cannot do, it seems to me. Does anyone have any comment, any opinions they want to share on that?
And I'm wondering if we want to, well, I guess we can't during this meeting address the family law as a whole because that's not on the agenda. But yeah, so.
Okay. So what I would like to do, so we're discussing child welfare and then conservatorship guardianship. I want to start with child welfare. We had a really good presentation. I'm thinking that we should allow paraprofessionals, there is a need. I see a gap in services with regards to the forms that Mary has on her list. So let's discuss it in two parts. Well, in three parts. Pre-filing, post exit, post, not really disposition, but an order, but the case is still open, where a JV 180 or something like that has to be filed. And then the other, de facto parent status and the request for information, and even the CACI SOC 834 form. So let's talk about pre-filing. I thought Mary's comments with regards to what the needs of the parents are when a social worker gets in touch with them was pretty compelling, in that the assistance a fully trained paraprofessional can provide in informing them of what the process is like, what the social worker is looking for, what documents are needed, and prepare them for the interview and even accompany them to the interview. Thoughts?
I'm in agreement.
Okay.
Yeah, I agree. I think that there are pre-filing, pre-removal of the child from the home. There's a large area that you have family maintenance that informally the agency may place the parents on. And so I think that there is a lot of things that a paraprofessional can assist the family with. So absolutely.
Okay. There's also just this kind of it sounds like negotiation to me even. You know, kind of work with the social worker and come up with a plan that protects the child as well as the parents' rights as parents. Okay. Anybody else?
Reba, do you want to take this in chunks? Do you want a motion to that effect?
I'd like to recommend that we don't necessarily need a motion if there's general agreement. And if you're comfortable with it, I can share a screen where I'm recording sort of what you're to reflect your discussion.
if we could.
Yeah, so let me, and then if there's general agreement, I don't think we need to have a formal vote.
And even in terms of having a list, I just think we could just talk about pre-filing stage in general and just authorize a paraprofessional to assist with all aspects of pre-filing tasks.
They're not really proceedings. Is this?
No, I mean, administrative maybe, but it doesn't really result in a court order. Everything is voluntary.
Right.
And if the social worker doesn't like what they hear, or if there's no agreement, then they're gonna go to a proceeding, file a case, and now you've got a proceeding. So I figure at all stages, pre-filing on all tasks.
Yeah. And I might suggest we include something like including but not limited to.
And list what she said.
The 3 or 4 things she said. The reason being is we don't want, there might be a department within an individual county where they're not saying, well, you're not a lawyer, I'm not going to let you come in. We better have this in the language, including but not limited to, requesting documents from the social service agency.
Legal advice and information about process and rights. That's what I wrote. And being, so go ahead, Linda, sorry.
No, can you repeat what you said just now?
I said provide legal advice and information about procedures and parents' rights at this stage. Being present and participating.
Hold on a second.
Sorry, I'm sorry.
Okay.
I should type faster. No, I'm just kidding. So being present and participating in social worker interviews.
And the last one would be gathering documents. Gathering documents to be presented to the social service agency.
Yeah, and that maybe that bullet point should be before the being present and participating in the interview.
Do you think we need to say that they can draft safety plans?
No, because I've never seen a non-agency prepared safety plan. They always do it themselves.
Yeah, safety plan and the voluntary plan.
There's actually a form that they use.
Judge Wiley, you said it. I forgot what you said. What is that result that comes after? Not reunification, but I suppose it's a parenting plan.
Well, we call it a family maintenance plan.
Family maintenance plan. That's right. That's right.
And I don't know if that is, jurisdiction specific.
No, I've heard it here too.
Okay.
This is before that. So in Santa Cruz County, people will present their own safety plan. It's not family maintenance. It's trying to get them to go away altogether and not file anything, either FM or for removal. So it says, I won't drink, but if I do, I will call my mother and my mother will come take the kids. They're very informal documents.
In our county, family maintenance plans are not filed in court. There's no court case. It's just an agreement between the parents and the agency.
So as long as this specifies that it's not limited to this list?
Yeah.
That's fine.
And it's pre-filing.
Prior to the filing of a juvenile potential defense. So I want to make sure that this language is accurate because this is what I'll use to draft the memo from your subcommittee.
In some way, do we want to reflect the ability of the paraprofessional to essentially negotiate with the social services agency?
As a separate bullet, Judge?
Yes, or do you think it's fairly subsumed in what we have?
I think it's covered by 4, and I guess you know what it is. I'm worried about giving that negotiation language, putting that out there. I think I don't know that that telegraphs the right message.
How about communicate with social worker, with DFCS on behalf of the parents?
Okay, I just want to again caution against trying to come up with an exhaustive list, because
okay.
that implies that we've captured everything. And I think if we
Okay.
just have a few bullet points and not try to capture every single task, I think that accomplishes the same thing.
Thank you, Linda, for
you.
reminding
Thank
us of that.
Thank you for.
How about you don't worry about how we go wild when we get lists, right?
I'm sorry for leading us down that dark.
And I think actually where the list is useful is in developing what the training requirements are. I think when we flesh out the training requirements, then we come up with a list to make sure that nothing is missed during the training.
Okay.
Right.
When are we going to do that? Just as a matter of process?
Well,
Because yeah.
I can't say right now, but it's definitely going to get done, because all of the subcommittees, the practice area subcommittees, are going to have to make those recommendations to the licensing
Okay.
subcommittee.
So again, 117, and we have a hard stop at 1:30. So
Right.
I'll move on. So the other stage, then now we're talking about the forms. So the forms that on Mary's list, let's just put it that way so we don't have to repeat it, right?
And is this to assist parties who are not entitled to court-appointed counsel? Do we want to say to parties, other than the parents and guardians and children, or do we want to specify to any parties not entitled to court-appointed counsel? How do you want to phrase that?
That's what I have in my notes, that we should really separate the parties, like with standing or not standing, between parties who are entitled to appointed counsel, because then they really should go with that.
Yeah.
And then parties who are not. So parties who are not appointed or entitled to court-appointed counsel, the paraprofessionals can help them with the list of forms that Mary talked about. Now we're just talking about forms right now. And maybe you can insert the form numbers, or
do we want to be limiting or not? Or do we want to let them provide a general assistance to people who aren't entitled to court-appointed counsel?
I think this is an exhaustive list of forms. There are no other forms that, right?
So then maybe we don't need to list them. Maybe we can just say that they can provide assistance to people who are not entitled to court-appointed counsel.
But I do think,
because what if new forms are added in the future?
And any other forms that are added to this, I don't know. I just think, well, maybe it is a part of the, maybe we'll be more specific in the education piece then.
Right.
You know, and then we have to talk about what if there is a court hearing as a result.
Right.
Do they get to go to court? Now,
right.
Again, I found Mary, well, Mary, obviously, like most of us here, grappled with that issue of whether it's better to have somebody with you if you're not entitled to court-appointed counsel. And she said, these people, and I've seen it in person, they're so traumatized, they're often dysfunctional, they're coming from a place of emotion and hurt that they took my kids away. They're not able to communicate effectively with the court, or respectfully for that matter. And a lot of times they're excluded because they just can't manage themselves. So I think it's, again, a compelling argument to allow for in-court representation in those proceedings.
I probably shouldn't have put Mary on the spot because I didn't realize that she wasn't briefed on the in-court representation issue, and she was grappling with it. So I think she was kind of like thinking about it on the spot, and I would love to come back to her and talk to her about it after she's had some time to reflect. But off the bat, I'll tell you that I'm having a really hard time with in-court representation in this realm. There's just so much at stake.
So Sharon, I just want to make sure you understand, these are people who don't have money, who don't to hire an attorney, who don't get court appointed. So they're either alone or could use the help of a calm, emotionally removed paraprofessional.
I'm well aware, like I sat in that courtroom for 2 years. I think that there's a lot that can go wrong, and I think it's a slippery slope. I don't think it's appropriate.
And it could go less wrong with the self-represented. Just ask.
When I think through what could go wrong, it can't harm the actual dependency case where the child ends up. It could harm the people potentially who hire the paraprofessional. For example, the grandparents who want to be de facto parents or who want visitation. They may lose, but their choice is to go it alone and have to say things in front of their own children that they don't want to say, or to have a voice in court. That's kind of where I'm ending up with it. I would like people petitioning for de facto parent status or visitation to have somebody with them who's allowed to speak.
I know they're not normally appointed, but can any of these third parties be appointed counsel by the dependency court on a request?
What did you say about that?
It won't be paid for by the system.
Yeah, I didn't hear that these people could get attorneys in the de facto parent status. And even in a JB 180 petition, they don't get an attorney appointed at the outset, at the entry into the system. But I do believe if the case gets protracted, I do believe the parent has a right to court-appointed counsel. So we could specify that unless there's a right to court-appointed counsel, paraprofessional can represent the litigant in court proceedings.
And the way it's written right now, it says parties not entitled to court-appointed counsel.
The other thing I heard was that the de facto parent applications could go to trial, lengthy trial, and complicated trials. So,
and I think we should be clear that people requesting de facto parent status, it's very rare. It does not happen consistently or routinely. I've done one in the 4 or 5 years that I've substituted in on dependency calendars. So it's extremely rare. Usually it is, I had the case that I'm thinking of. They were grandparents, maternal grandparents. They wanted de facto parent status so they could be they could attend all the hearings, get information, et cetera, and then ended up eventually adopting their granddaughter. So that's a little bit, I think, of a rare situation. They had their own attorney that they privately paid for.
And once they got de facto parent status, so they're then a parent, so they would have been entitled to court-appointed counsel, right?
right, and they have a seat at the table standing. Yeah.
Correct.
So I think, so that, Judge, you're in support of not excluding that.
I've been in support of not excluding that. I am essentially the way that it's written. If anyone is not entitled, and again, keep in mind, at least when the case is active, everyone has an attorney. And I think that there are enough protections in terms of what's in the best interest of the child in that situation, so that if someone is coming to this process with, regardless of what they have standing, but trying to exercise whatever remote legal right that they may have at that point in time, then I think that they should have the option to have a paraprofessional with them in court, advocating again for whatever remote rights they may have at that point in time.
Okay. Do we have most of you in agreement? Anybody disagrees? Time to talk now. Okay. I think
I'm going to be like the dissent. I'm going to disagree.
okay.
So if you're the only one who's disagreeing, we can note that in the memo, saying that there was disagreement.
Okay.
I'm still, can I be an abstention? I'm really struggling. I'm having a difficult time
Well, yeah.
supporting it, given my prior position regarding in-court representation, as well as hearing what Sharon's saying. So I'm not in favor of it, but I see
Yeah,
that.
I have to tell you, Steve, you know, I was one of the 4 votes, you know, against full in court representation on that Friday. And I think that for some of these, when I've seen these parents in these proceedings where they don't have right to counsel and they just go in there and can't do anything. So it's a well-trained, and I think that's where we need to really approach this, is from the education standpoint and CLEs and making sure they're plugged in if they choose to do this. And that's the other thing I wanted to say is if you sign up for a family law specialty, are you signing up for the entire gamut, or do you get to choose family law, guardianship, conservatorship, and then child welfare? We have talked about that too.
Yeah, I think those have to be different specialties. I think there needs to be a separate unit course on conservatorships that's independent of the family law course.
I think that based on what we heard also from public testimony about, you know, the fact that you need expertise in this, I'm having a hard time thinking that a paraprofessional can take a like 1 unit class or do a few hours under an attorney and they're going to go and represent people in juvenile dependency cases.
I agree.
We don't have to have the educational issue resolved before April though, true?
That's correct.
So I think Sharon, when I said the 1 hour, that was strictly limited to the limited, assuming we go with the limited conservatorships, that was strictly conservatorships only. I wasn't addressing the dependency court. And I think dependency court, if you're going to let them do it, I think when we address the education, that might be the place to raise the standards given how important that court is and that we can't have people thinking that they're getting adequate representation when someone only took a 1 unit course. I'm with you on that one.
And I didn't mean it literally. What I meant is given the other constraints of trying to get a paraprofessional program off the ground and looking at what happened in Washington State, no matter what we do, they're not going to have, it's not going to be that exhaustive. So it may not be 1 hour, but what are we going to really put in place here?
Yeah.
Open-ended question.
Got it.
Okay, so coming up on 128, Linda, realistically, I think we did really good on this piece. I think we have a position. And
is it the same position in terms of after the case has closed that they can represent and anybody after the case is closed?
I think the second provision there really covers it. It's just,
okay.
as long as they don't have a right to court-appointed counsel, the paraprofessionals can step in and help. That
Okay.
covers all the
That's
other
fine.
forms and all the possible ways that a paraprofessional can step in.
I have
Okay.
Zoom court in a minute, so I'm going to be logging out.
Yeah. So do we have agreement about the limited conservative, the limited conservatorship?
I think that I don't want to rush us, but I do believe that we may have an agreement on the limited conservatorship piece. If we have to uncontested limited conservatorships, they're mostly 98%.
So I can put that in the memo and you guys can give me your feedback in the memo just so that we can keep this moving along.
But now we have guardianships and general conservatorship still on the table.
Right.
And then the other issues. So I you know, if we're gonna have a presentation for the group meeting on April 19th, do we want to meet next week just to finish it up?
Sure. Do we? Is there, we would need to figure out a time. Should I send out a doodle poll? Do you think we could have like a 1 hour meeting would be enough time to finish?
Do people have 1 hour sometime next week? I'm not asking you to specify what time because Linda's going to send some doodle poll out. But is there a strong objection to meeting 1 hour next week?
No,
I'm just kidding.
Okay, I'll try. I'll send out a doodle poll for something early next
We'll
week.
just finish.
Okay.
Before,
Great.
Dana?
before we leave child welfare, that second bullet says,
Sorry.
during a child dependency case. Those JV 180s, the 388 motion to amend, those can happen after. So I don't think it does cover post dependency 388 motions. And I think we need.
Actually, I think it does, because I may be wrong here, but if the juvenile dependency case is exited into a family law case, a JB 180 cannot be filed. So the case is still open, it's just not active. So we could say in an open juvenile dependency case, we don't have to say during a case, but as long as an exit order is not filed, papers can be filed in that case.
So long as those orders are active, they can be changed with a 388. So I just want to be clear that we're allowing paraprofessionals to file those.
I think we are.
Like that.
I think we are. Anybody have a question about that?
And maybe we can touch on that in our family law meeting, because most of the exit orders do exit to family until the kids are 18. So how about we
Okay.
do?
Sounds good. All
Sounds
right.
good. All right, everyone. Thank you.
Thank
Great
you.
meeting. Yay. Bye.
Bye.
Linda, see you in a minute.
Yes.